Hello, everyone. This is Tom Fox back for another episode, and we're all in for a treat today because finally we have Ellen Lafferty on the podcast. Ellen, first of all, welcome to the podcast.
Thank you so much, Tom. I appreciate being here.
Ellen is, I think, well known in the compliance community, but she's had a long and distinguished career in financial institutions and educational institutions, and now her book, Anti-Bribery, Corruption Law and Compliance in a Nutshell. So we are going to explore all of those and see what all of this means in the age of 2025. Ellen, with that incredibly long-winded introduction, let's start with your book. And what inspired you to write this book? Because I always love to talk to other authors about what got them going.
Oh, thanks. Absolutely. This has been on my mind, the information in this book, for quite a long time. So I've been working in anti-corruption in various capacities since around 2008. So as outside counsel, in-house compliance officer, different roles. And I'm originally a litigator by trade. And as we know, companies almost never litigate FCPA cases. So this was new territory for me when I started. Unlike other areas that I previously worked on as an attorney, there's no bank of judicial opinions I could draw from, no one single place to go to get the information that I need. So I found myself looking at lots of different sources for information: congressional reports, judicial opinions, speeches from DOJ, SEC officials, deferred prosecution agreements, international law enforcement guidance. It keeps going. And it was really a patchwork. And to perform in my given roles, I felt like I had to put all those pieces together and analyze them in order to provide advice and really do my job. And what I wanted to do was try to share what I learned with other attorneys and compliance officers, hopefully that it would help them in their work as well. Honestly, I tried to write the book that would help me in practice. And so that's why I hope it will help others too.
So let me explore one thing you said, which was your prior career, as you called it, a litigator. I would call it a trial lawyer. So I'm a recovering trial lawyer. I did for 25 years. But the thing I found it gave me in the anti-corruption compliance world and even in-house was that I understood I always thought about who's the ultimate audience. Well, in my world, that ultimate audience was a trier of fact, whether it was a judge or a jury. And many in the in-house world who didn't have that experience, they didn't think about that in either drafting a contract or putting in terms and conditions, or sometimes even an investigation. So I was wondering if you might give a few thoughts on maybe that perspective you had as a litigator, that there was always someone above who would ultimately, if not judge you, review your work, and what that did or how that allowed you to maybe see a broader picture.
Absolutely. Thank you. And I think litigation, I really did learn, I think, a lot of from being a litigator that I could transfer to an in-house role. And I think I was so set for a while on being outside counsel. It was a bit of a transition when I moved in-house. But what I always did think was, even though I'm in-house, I always thought this bank, for example, this financial institution is my client. And all the people I advise here are my clients. So I have to think about how I explain this, how I explain the choice that the client has to make, how I explain the potential consequences that might face the client. And I have to really get them on board with the advice that I'm providing and understanding the situation that we're in. So I think that really, like you said, being a litigator, you're always explaining to, and that's certainly your client, but in that case, to the trier of fact. And I felt like I had a lot of triers of fact, so to speak. When you learn to manage not only up as a compliance officer, up, down, sideways, you learn the concept of stakeholders. You know, how there are so many people that play some vital part either in your program or are affected by it in some way. And you have to figure out how to explain to all those different constituencies your position and how these decisions affect them. So I actually think the litigation piece for me was very helpful. I took it with me in terms of figuring out the advising my client piece.
The other thing that intrigued me about the scope of your book is the breadth in terms of it's both law and compliance. And you really put those together. I wanted to maybe delve into that a little bit. That even the title indicates to me there's multiple audiences or even stakeholders for this book. And then How would you hope or advise a compliance practitioner to use your book?
Sure. Thank you. And I did try to make it broad in scope. And again, like I said, I wanted to try and take all those pieces that I needed to do my job as a lawyer, as a compliance officer. I wanted to try and put those pieces together in one book that someone could use as really a concise reference and a jumping off point for any questions that they had. And so I really wanted to try and have I wrote it for a broad audience. I wanted to include both legal and compliance students as well as practitioners. I teach at Fordham Law School right now, teaching anti-bribery and corruption compliance, FCPA compliance, and many law schools, including Fordham, obviously. And I think this is very wise and a sign of our times. Many of these law schools have courses and really entire programs dedicated to compliance. So I wanted this book to be relevant and useful for both law students and compliance students. And then to your point about practitioners in both of those spaces, I'm hoping that this book is, if you have it in the hard copy or if you have it electronically, that it's something that people keep nearby that they can refer to. And as you said, it's both the law and compliance. And I wanted people to be able to say, you know what, I'm sitting here, an FCPA matter, maybe you're a general counsel at a small company, an FCPA matter crossed your desk. You pull it out, you're able to say, you know what, I haven't looked at this in a while. You're able to take a good look at the law. I tried to break down a lot of the concepts in the FCPA so that they were hopefully more digestible. So to keep nearby as a reference on the law when you need it, but also to be able to look at specific questions and issues when they come up in practice. So, for example, I was speaking with an attorney I used to work with who's now in-house at a tech company. And she told me she was thinking of sending a transparency letter because to the invitees for an event that her company was doing. It was a high-priced event. They were inviting public officials. And she said, I was thinking about transparency letters and I haven't thought about those in forever. She said, and I really appreciated the comment. She said, when I pulled out your book, she said, and I looked up transparency letters and I refreshed myself and I thought about it and everything. And so I was like, I thanked her because I said that was a great example. And I hope that, that it can be useful, to people in those kind of practical ways. And I also, to that end, I put a pretty detailed table of contents in so that the reader can easily find a particular topic and look it up and read about it.
So let's turn to the current scene as we're recording this in late June 2025. Obviously, on February 10, we had a major announcement of suspension of FCPA investigation enforcement by the president. Then, starting in May, we had a series of memos from the Department of Justice on criminal enforcement policy, white collar issues, thoughts on whistleblowers monitors, leading to the Blanche memo on FCPA enforcement going forward. Was that memo, I guess maybe start with how did you feel about that memo? Was it consistent with the priorities you saw from this administration? Did it take things in a different way, or is it really consistent with many of the things we've heard? I'm going to say at least since Sally Yates, when we're going to prosecute individuals.
Yeah, definitely. I don't think it's consistent in terms of going back to Sally Yates. I don't think it's consistent with everything we've seen since then, but we can pick that up. But I do think it is consistent with what we've heard from this administration thus far. So looking at it, like you mentioned, that February 10th executive order, that and a lot of the speeches around it kind of set the tone for what we were going to see. And I was surprised and glad that the guidance came out in a timely manner. And it basically asks prosecutors to to take into account four different priorities when thinking about whether to bring an investigation or an enforcement action. So the first is total elimination of cartels and transnational criminal organizations, something we heard in the Bondi memo. Safeguarding fair opportunities for U.S. companies. And this is something we see the word America a lot, right? We hear it in all these speeches. We see it in the executive order. We see it in the memoranda. Safeguarding fair opportunities for U.S. companies. And the language, I think, was interesting. It was very specific in terms of these priorities. And for this one, it was whether the alleged misconduct actually deprives specific and identifiable U.S. entities of fair access to compete or result in economic injury to specific American companies or individuals. So you have this theme of maintaining competitiveness for American companies, and that's been something the president has emphasized for quite a while. And then national security is the third priority. Whether the alleged misconduct involves national security sectors or assets like defense, intelligence, critical infrastructure sectors, this again goes back to the executive order, which talks about how national security kind of depends on US access and US companies' access to some of these key resources in other countries. So I wouldn't have thought about that specifically, the FCPA, before in this very narrow national security context, but that's not surprising given what we've heard. And the last one is kind of a common sense one, I guess, is prioritizing investigations of serious misconduct. And to your point about individuals, this, right, we have, going back to the Yates memo, always the Department of Justice has emphasized this idea of we want to hold individuals accountable, right? People are corporations or entities, right? But it's individuals behind here that are actually making the decisions. And this piece, this last priority about prioritizing serious misconduct, it emphasizes corrupt intent tied to particular individuals. So not general corporate malfeasance. So not some of the failure of compliance program cases or the risk of bribery cases. We're talking about serious misconduct tied to particular individuals, and we're going to seek and punish those particular individuals. It continues that emphasis on, I think, holding individuals accountable, but it narrows it, I think, even a little bit more. So that, I think, was definitely interesting. We're also seeing, I think, with that fourth piece, the investigations of serious misconduct. And I'd love your thoughts on this. It seems like we're backing off a little bit from generally accepted business practices, courtesies, conduct involving low dollar amounts, and taking that at face value. Those shouldn't have been FCPA cases, just really involving generally accepted business practices, et cetera. They should not necessarily have been FCPA enforcement actions anyway, but we're again seeing that whole let's not disadvantage American companies. And we see a comment in the guidelines too about reminding us about facilitation payments, for example, that there is an exception in the FCPA for facilitation payments, which certainly has been, I think, invoked less over the last few years. But now I thought it was interesting that it called out facilitation payments. In terms of prioritizing investigations of serious misconduct, I think we're looking at individuals, as you mentioned, but then also really maybe cases where the misconduct involves senior individuals or is widespread or involves efforts to obstruct justice or some other type of fraud. Sorry, that was a really long answer, but.
So the facilitation payments, we've had some cases over the years, but my experience has generally been that's either an add-on or a throw-in to show a culture or a mentality around compliance that allows high expenditures in those categories. And it's never the sole basis of an enforcement action. And I don't know if you remember, there was one case where a wife of a government official got $3,000 worth of roses, and that was cited. And we've had the cases that say, oh, they got a Rolex watch, or they had a $2,500 dinner, or expensive bottle of wine. But I can't remember, even the SEC has not been able to successfully prosecute individuals around facilitation payments. I guess either that didn't surprise me more, I just had a very long yawn on that part of it. But I have gotten calls that are along the lines of, oh, can we increase our expenditures for our gifts, travel, and entertainment or business courtesies? And I'm like, you could always do that. But one, what is your risk tolerance? Two, how much discretion do you want to give your individual salespeople? And then three, is it actually going to benefit you from the business side of things to give a salesman an unlimited dinner expense or buy Super Bowl tickets? So you still have to kind of go through that analysis. And I wanted to talk about that in the context of what does all this mean for a compliance professional now? Can they just we just call it facilitation payment, check the box, and we can go forward? Or are we still actually needing compliance professionals to do compliance inside of corporations?
Yeah, absolutely. And I do think that question, right, all the executive order and then everything that happened since, It really does bring up that question. And just to your point about the facilitation payments for a second, I agree, definitely not surprising from a legal perspective. But from the compliance perspective, I was thinking, I just thought it was interesting that it was mentioned because it was from a compliance perspective, so many organizations, even though facilitation payments have been permitted for a long time under the FCPA, for a lot of reasons, a lot of companies prohibit them internally. So it's been almost a subject of non-discussion for a while. So I thought we're bringing this back in. And as you said, it also raises the question of the language in there raises the question with gifts and entertainment. Should you have changes to your program? But absolutely, I think we're so focused on the change right now or our perceived change with seeing these guidelines. But I think we absolutely need compliance officers. And it's the role of compliance officers, right, is even more important, I think, at times like this, where you do have some shifting, maybe some shifting national priorities, and guidance reflecting that. But I think that we need to remember a few things that compliance officers, when there's a lot that hasn't changed, right? The FCPA is still the law. It has the bribery provisions have a 5-year statute of limitations, the books and records 6. So when we're talking about advising the companies we're at or the companies we're working with, the conduct those companies are engaging in now, much of that conduct will still be in play when potentially other guidelines might come out or a new administration in 3.5 years might change an approach. So we still have the law in place. We really need to make sure we comply with it. So that hasn't changed. And also, from the encouraging point of view, from a compliance perspective, these enforcement guidelines, we do have those 4 priorities that I mentioned, but those are non-exclusive priorities. The guidance is clear that obviously the DOJ is still subject to and operates by the principles of federal prosecution of companies, et cetera. So I could see there being certainly other cases that the DOJ, investigations that the DOJ brings that don't fit neatly within these 4 pieces.
We both teach at universities. You're at Fordham, as you mentioned. I teach at Case Western. I'm teaching this summer, and there was a lot of discussion from the students early on. Do I need to focus on law school stuff and not compliance? Do I need to quit thinking about compliance as a career? And I was wondering, one, if you were getting questions similar to that, and then two, what was the discussion you were having with your students on those issues?
Sure. I have gotten some questions along that vein as well. And because I think that, like I said, with the guidance, I think people and the executive orders, I think there's a tendency almost to react too much, to the change. And like I said, I think we should focus on a lot of what's the same. And to me, the law is certainly, like I said, still in place. But in terms of compliance, I think, and what I've shared with the students is every administration, right? This is a little bit different, but every administration certainly has different enforcement priorities. We always see on a regular basis, especially over the last few years, evolving guidance, even before this administration, from, for example, the Department of Justice about which cases that they would pursue and about how cases would be resolved, et cetera. Compliance personnel are always going to be needed to make sure that the law is translated effectively to policies and procedures, to translate to training employees, to translating what outside standards are and what the internal company standards are, and making sure employees comply with them. The map may change, but you always need somebody looking at the map and driving the car on that road.
The other thing I've tried to emphasize is now may be a time to do either a self-assessment or maybe a deep dive with your own team into your program. You could look at your internal controls. You could do a gap assessment or gap analysis. You could do a self-assessment. You could maybe look at your third-party program with resources you currently have so that it's not going to be a budget increase. Are you having those discussions, or are you giving maybe that advice that now may be a time where you can really take a deeper dive into your compliance program and make it more efficient?
Mhm. Absolutely. Because you always think about, I know and I've gotten this question a little bit more recently when we had that 180-day pause, and people said, what, the FCPA is not being enforced for 180 days. It's, unless your company was actually in an investigation then, or had a specific matter pending, that didn't necessarily change anything for most companies. But to the extent that again, but to the extent that we're waiting for guidance, et cetera, and now, that we have this guidance, it's absolutely a time where teams can take a harder look, maybe a harder look at that program. And if thinking about it from a positive perspective too, like we talked about gifts and entertainment, and you said, and you've gotten a couple of questions on this, and I have two about, could we maybe, given the language here, could we maybe, from a company perspective, could we maybe loosen up our rules a little bit around gift giving, or could we maybe raise the thresholds of what we require for approval, et cetera? So to the extent that maybe that area might not be a focus, we want to really think about where our real bribery and corruption risk is. And you gave a great example about certainly third parties. I think that's historically an area that companies don't look at enough, their third party risk. But I definitely think and I have spoken to companies about this, and I definitely think it is a good time when you have a perceived lull. I don't think has actually been a big lull, but I think that whenever you have a perceived break, I think it's always a good time to take a deeper dive, to take a look, to use the time.
Ellen, if you could maybe have a wish list or what you would hope listeners or readers rather of your book would take away in the context of what we just discussed of what's happening in 2025, are there some key messages from the book that you would really like the various stakeholders who would read it to take away?
Yeah, thank you. Thank you. I think a combination of things. I think from both the book and from, to your point, the times we're living in now, we have certainly compliance. Being a compliance officer is a challenging role, and I think that's always one of the things that I've liked the best about it is we always need to protect our program. And I think that's one thing that I'd like the listeners to take away today is maintain the momentum. Keep anti-bribery and corruption concerns top of mind. We are in a time of some uncertainty, and I think that always, right, compliance has sometimes suffered from the idea that it's a cost center, that it costs the company money. And you could see at a time like this where the human temptation of senior management might be say, all right, you know what? The administration is signaling that FCPA is not a huge priority. And to the extent it is, the administration is going to focus on four very narrow categories. Compliance officers, we need to recast that message. We need to maintain momentum for our program. We need to remind our stakeholders, as we mentioned, we need to remind them that of the law that's in place. We need to remind them that right now we're in a little bit of a wait and see approach. And what that is, that doesn't mean sit back. That means maybe take a deep dive into your own program. That also means to really stay on top of what happens next. And there's a lot of different ways we can do that. And I'd like compliance officers to think about that, certainly. So certainly staying attuned to any further government guidance, speeches by government officials, which I always like to read the speeches that come along with guidance that's issued like this, or executive orders, because often unofficially, but they amplify or really explain the guidance a little bit more. And you hear it from the government's perspective about what they're actually looking for. I also want to note that we really want to watch for concrete examples of investigations, enforcement actions that are coming up with these pursuant to these new enforcement guidelines. We're reading them, we're thinking about them. There are a lot of, for example, law firm memos out there. There are a lot of different articles about what might these guidelines mean in practice. And you and I both have certainly some ideas on that. But right now it's all somewhat hypothetical to me. The priorities seem fairly narrow. So I'm interested to see how that plays out. But again, those four factors aren't exclusive. And we could certainly see enforcement actions that are more like what we've seen in the past and that don't fit neatly within those four pieces. So I think we want to stay attuned for further guidance. We want to watch for concrete examples of what are these investigations going to look like? What's the first enforcement action going to look like? And for compliance officers also to keep benchmarking to the extent they can, to participate in industry groups with other compliance officers who work with companies in their industry, companies similar to theirs, and getting a sense of how other companies may be responding to current challenges. You always have to make your own decisions, but I did always find that, for example, participating in anti-corruption working groups for the financial services industry, I always found that very helpful. So I think really my main message is to stay the course, to pay attention to what happens next, and to protect our anti-bribery and corruption compliance programs, because honestly, that's how we protect our company. That's how we protect our employees.
Ellen, you didn't know this, but you get a special gold star if you give me the title of the podcast episode in your remarks, and you just did. Stay the course. So,
oh, there. I didn't
extra
know that.
gold
So
star.
we're on the same page then.
Yes. No, I didn't want to put any pressure on you. So there you go. Unfortunately, though, we're near the end of our time for this episode. But before we leave, I wanted to ask you if any of our listeners wanted to connect with you to find out more information about the book and certainly purchase the book, what would be the best place or places for them to go?
Oh, certainly. The book's available in softcover and electronically on Amazon, as well as through West Academic Publishing. I'm on LinkedIn and I'm reachable at my Fordham email, which hopefully we can share in connection with this podcast. It's elafferty1, the number 1, at fordham.edu. I'm always glad to hear from people who want to talk about anti-corruption issues or have any questions about the book. So I'd be happy to get in contact.
Ellen, I wanted to thank you again for taking the time to visit with us, and I promise it will not be as long before I have you back on.
Thank you so much. I really appreciated the opportunity, and it was great talking with you today.
Compliance Podcast Network. Start your mornings with daily compliance news, quick, sharp updates on the top compliance and ethics stories in under 5 minutes every morning in Compliance Podcast Network. Because compliance never sleeps. Need practical advice fast? Check out Compliance Tip of the Day. One actionable idea to level up your program. Short and sweet, every day on Compliance Podcast Network. Got 10 minutes? We've got the week's top 10 stories. 10 for 10 brings you the big compliance headlines. Fast, fun, and focused. Every Saturday on Compliance Podcast Network. And don't miss the Sunday Book Review, where compliance meets culture through must-read books and big ideas every Sunday in Compliance Podcast Network. Whether you're in the office, on a walk, or commuting, stay smart, stay ethical, stay tuned. Only on the Compliance Podcast Network, available wherever you listen to podcasts.